It's such a pleasure to be joining you right here on the India Development Debate right here on ET Now. I'm Supriya, Shrinate, and with me in Mumbai is Sandeep Gurumurthi. Let's take it straight across to an issue that has grabbed headlines and perhaps the time has come to review it. Finance Minister Arun Jaitley may have set the cat amongst the pigeons by calling for a review of the anti-corruption law. The Union Minister says Prevention of Corruption Act is out of sync with the times and has ended up as a tool for bringing elected governments to a standstill. The provocation, of course, for Jaitley's diatribe is the arrest of the CMD and other top officials of the Bank of Maharashtra by the Pune police on corruption charges. Industry has raised a toast to the minister, stating that overzealous law enforcement agencies cannot play with people's lives. In fact, Jaitley is not the first one to talk against the 3-decade-old law. Faced with a barrage of criticism against the policy paralysis during its second stint, former Prime Minister Manmohan Singh had come down heavily against the law agencies for creating a fierce psychosis amongst top government officials.
While there may be a case to look at a 3-decade-old law, nothing can and must come in the way of cracking down on corruption. The government must create an environment where officials can take decisions without fear. It must not dilute or have a kid glove approach, of course, to graft, considering how deep-rooted corruption is in India. So how to strike the right balance between the fight against corruption and anti-graft optics? That's the topic of discussion tonight on the India Development Debate. And joining us is a wonderful panel this evening on the show. We've got Prashant Bhushan, senior lawyer and an anti-corruption crusader; Aman Sinha, spokesperson of the BJP; Mohammad Khan, spokesperson of the Congress Party; Sadanand Dume, resident fellow, American Enterprise Institute, also joins us on the show this evening. And we've got C.H. Venkatachalam, General Secretary of the All India Bank Employees Association, representing the banking industry. Thank you all so much for joining us on this edition of India Development Debate. Sadhana, let me start off with you. Union Minister Arun Jaitley says the Prevention of Corruption Act is counterproductive and has ended up as a charter for bringing the government to a standstill. Do you agree?
Yes, the short answer is I do agree. As pundits and commentators, very often we reflexively tend to criticize the government, and very often the government deserves criticism. But in this case, Mr. Jaitley is absolutely right. I think there is a broad consensus on this issue among what I would call the sensible center. Everyone from Manmohan Singh to Arun Jaitley recognizes the cost of the 1988 law. The fact is that it has not controlled corruption in any significant way. Any reasonable person would say that India has become much more corrupt over the last 30 years. And at the same time, it has indeed scared many officials and prevented them from doing their jobs. So I think in the interest of moving ahead, it is sensible to take another look at this legislation. And what Mr. Jaitley is saying is absolutely correct.
Okay, let me just take this across to Prashant Bhushan, who may perhaps actually disagree with you there. But Mr. Bhushan, hasn't institutional activism that we've seen in the time of UPA and now the fresh signs that we're seeing in NDA towards the fag end of the tenure, hasn't this sort of institutional activism and the clamp down by investigative agencies failed to differentiate between genuine decision making that may have gone wrong in hindsight and what is nullified decision? Investigative agencies went ahead and arrested the top officials of Bank of Maharashtra. They may not be able to prove charges, just like they arrested 4 IDBI officials last year and have not been able to prove charges. But damage has been done. Reputations have been tarnished. People will be scared to lend. I'm just asking you, has the differentiation ceased to exist between what is perhaps a decision wrong, gone in the hindsight, versus nullified intent?
Well, yes, sometimes this is happening. And this is happening not because there is anything wrong with the law. It is happening because the enforcement agencies, including the CBI, are not doing a proper job. The Lokpal has not been formed, and the CBI has been brought more and more under the control of the government, with the result that the government is using the CBI now as an instrument to harass all and sundry. The professionalism of the CBI has been destroyed. See, what does the law say? We need to understand there are 3 sections in the Prevention of Corruption Act which create offences of corruption. The first is section 7, which says taking gratification as an official, if you take gratification for doing something. The second is if you are dealing with the file of somebody, and then you take a gratification either for yourself or for somebody else. That's also an act of corruption, that's section 11. And then there is section 13, which is criminal misconduct, which is the problematic section according to all these pundits like Arun Jaitley, Manmohan Singh, etc. Criminal misconduct says that if you grant an undue financial favor to somebody, either by abusing your authority as a public servant or or without any public interest whatsoever, then that's an act of criminal misconduct. And then there is possession of disproportionate assets, which is unexceptionable.
Oh.
Now it is really this criminal misconduct which is the
bone
issue,
of contention.
which is the bone of contention, where people are saying
Sure.
that the enforcement agencies are sometimes unable to distinguish between a bona fide wrong decision, which may be a wrong decision in hindsight,
And one that was taken
or
with,
a decision which has been taken by abusing your authority
okay.
and without any public interest.
Okay, I take that point, Mr. Bhushan, and what you're effectively saying is incompetence of CBI cannot be an excuse for making amendments to the law. That's the sum and substance of your argument, and we will debate each of these clauses in detail in just a few moments from now. But let me get opening comments from the other panelists as well. Mohammad Khan, I'll come to you. Does the political class also need to be blamed across the board for lowering the threshold of evidence whenever it sort of comes to corruption? You fling charges, you just name someone, defame someone. It's the easiest thing to do. So is the political class also to be blamed in this regard?
Well, Sandeep, I think you would agree that if there is any political party who has been at the receiving end of that mudslinging, it is the Congress and its leaders who have been vilified without proof and have often been accused without charge. So yes, I agree with you. There has been a lowering of the threshold, but it's not been by us, it's by them. But the debate here today is about the law. Does it overreach? Is it egregious? Does it make it difficult for officials to perform their functions without fear or favor? And the answer to that question is, yes, the law is fine. The law is absolutely fine. It is the enforcement. It is enforcement through the various agencies. Some are overzealous, some act on political instructions. That leads to an issue where we say that the law is flawed. But the law is not the cause of concern. It's the agencies tasked with enforcing it. Now, let me tell you another thing. Earlier this year, not this year, last year, this government introduced a bill, and Mr. Jaitley is aware of that, which is why this debate becomes somewhat ironic, where they introduced a clause saying that officials cannot be investigated unless prior sanction is taken. Earlier, you would only need to take prior sanction from senior officials when prosecution was to be launched. You could investigate anybody, but when you decided to prosecute them, you would need permission. They made it a prerequisite for investigation as well, thereby making it harder to even conduct or begin investigations. So Mr. Jaitley and his government have diluted the law to that extent. There are also issues with regard to the protection of whistleblowers in that bill. Currently, that bill is the subject matter of the standing committee and another select committee in parliament, so it wouldn't be appropriate to discuss it further. But that shows you the political will that you were talking about. They're trying on the one hand to dilute it, and on the other they give you these motherhood and apple pie statements about the fact that officials can't work. So I think, yeah.
Right. No, Mohammad Khan, there are specific questions. There are specific questions that we have on some of the points that you've raised, but I just want to get opening comments from each one of them. And I will come to the point that you're raising on whistleblower. I will come to the point that you're raising on section 13(1)(d) and 13(1) in its form. I will come to all of that, but give me a minute to just get opening remarks from everybody. And Aman Sinha, I'll come to you. On the one hand, the government says it has cracked down on corruption like no other political establishment before it has. And then you are moving to dilute the most potent anti-corruption law. How are you going to reconcile the two things that you're saying?
No, Supriya, you're right that the kind of policy initiatives, legislative enactment in fight against black money and corruption which have been taken out by this government, no government in the past has ever even attempted. So this government has delivered. Not only one, Mr. Prashant Bhushan is sitting here. There was a SIT which was not being constituted by the Manmohan Singh government, and the first decision of the Union Cabinet when it took oath after 26 May 2014 was to constitute the SIT on black money. Thereafter, there are several such legislative enactments, whether it is Benami Transaction Act, whether it is demonetization, GST, the Fugitive Economic Offenders Bill, etc., which has now been made into an enactment. So several policy initiatives which have been taken, which clearly were a big substantial headway in fight against corruption and black money. Now, as far as amendments to the Prevention of Corruption Act is concerned, obviously this statute, which is about 30 years old, this seems to have outlived its utility. It needs to be strengthened and amended, and in fact the amendment is a part of strengthening the statute and bringing it in tune with the contemporary times, with the kind of offences which are being committed. It has to be in tune with that, and therefore all the amendments which are coming through, which have in fact been suggested by a select committee of the parliament. It is not as if BJP has made certain suggestions only to this. There is a select committee which comprises all political parties, members of all political parties, and they have made certain very feasible, viable suggestions in order to make the act more effective, more pragmatic. And this is not only going to strengthen our fight against black money and corruption, it will also allow us to get rid of excessive red tape and the slow decision making process which used to be there. We do not want our bureaucracy to suffer from any fear psychosis. They should take decisions on merit.
Okay,
they should be able to
Aman Sinha, allow me to
be able to take decision
okay,
without worrying about the fact.
Sure. Allow me to interrupt you there for a moment, Aman Sinha. I get your opening comment. Let me get a quick word from Mr. Venkatachalam, and then we get down to the specifics that Mr. Bhushan has raised, and I'll have the two of you, go head on that front. But Mr. Venkatachalam, is it unfair to water down anti-graft laws in the name of saving economy, in the name of a credit freeze? Like Mr. Bhushan has pointed out, if the problem is with investigating agencies, then probably, is the right approach in amending the law?
Yeah, see, already it's a matter of shame that India is one of the most corrupt countries. So we need much more tough, much more stringent anti-corruption law. So in the amendments are required, but it must be more to, catch the culprits. But now by diluting, we are only worsening. So we can't say that in the name of tuning the law, we want to dilute it. That's what the government is trying to do. But I strongly feel that much more tough anti-corruption law is required. To that extent, the changes must be made. But what they are now trying is to, have their own agenda. So it's very unfair what they are trying to do.
Yeah, they may have an agenda, but I don't know how are you going to reconcile to the fact that bankers are being now taken into custody and arrested, the CMDs, and I don't know what does this do to the entire morale of the banking system. How is anybody going to lend from a bank where the CMD has been jailed? I do think some amount of time and effort needs to be invested in that, but you make a point and I think I'll take it on board. Mr. Bhushan, I'll come back to you and let's get down to specifics right now. Amendments to section 13(1)(d) of the PCA, and under this new definition, any benefit that is not economic, that is indirect, or that cannot be proven to be intentional fraud will not be punished as corruption. Why do you believe this is a major dilution?
I have not read exactly because earlier the amendment that was brought, the amendment that was proposed were basically of two kinds. One was to require prior permission of the government for investigating any public servant. Now this was done initially by way of a single directive in the for the CBI, which was struck down in the Hawala judgment by the Supreme Court by saying that this makes a mockery of the anti-corruption investigations, because how can you say that the permission of that very government has to be taken which is to be investigated for the investigation itself? That's absurd. So the Supreme Court struck that down. Then they tried to bring that through the amendment in the CVC Act and the CBI Act. That was also challenged. That was also struck down. Now that same amendment is being proposed in the Prevention of Corruption Act. The other amendment that is proposed is to remove this definition of criminal misconduct and replace it by something else. The point is, what is wrong with the present definition of criminal misconduct? All that it says is that if you give an undue benefit to somebody, financial benefit to somebody, without any public interest and by abusing your authority as a public servant, then you are guilty of criminal misconduct. You don't have to prove that you have taken illegal gratification, because very often it is impossible to get evidence of illegal gratification. But if you have given an undue financial benefit to somebody with no public interest whatsoever, or by abusing your authority, then it will be presumed that you have done it for corrupt considerations or fraudulent considerations. So there is absolutely nothing wrong with this. The problem is that very often the investigating agencies or the investigating officers don't understand this clearly enough, that what does it mean to say without any public interest and by abusing your authority as a public servant.
Okay.
And that is why I say that the blame lies on the doors of the investigating agencies, where professionalism has been sacrificed and where political influence has been brought in.
Okay, I take that point on board, Prashant Bhushan. Let me bring in Aman Sinha. Let me get Aman Sinha to respond to that point very quickly. Aman Sinha, respond to the point made there by Mr. Prashant Bhushan. At the heart of this debate is Section 13(1)(d) of the Prevention of Corruption Act, and the fact is, after all, major cases of corruption were alleged on account of Section 13(1)(d), be it the 2G scam or the Commonwealth scam. This section, in a sense, is the crux of the Prevention of Corruption Act, and this definition of criminal misconduct is being tweaked, and people like Mr. Bhushan believe, to dilute and to sort of, in a sense, take the sting out of the Prevention of Corruption Act. How would you respond to that, Aman Sinha?
No, Sandeep, I believe the amendments would lead to strengthening of the provision, and there are several amendments which have been suggested by the select committee. Earlier, if a commercial organization used to give any bribe to any officer or any individual, many a times, our authorities, investigative authorities were, grappling as to under which section that should be covered. Now the specific amendment which has been suggested, the commercial organization is also would be held guilty and liable for the offence. So the amendments which are being suggested, they are yet to be obviously enacted by the Parliament. So therefore, they are open to debate. But all I can say is that all the amendments which are being suggested are only to strengthen the Prevention of Corruption Act and to make it in tune with the times that exist today. The issue of prior sanction for prosecution, etc., which is there, let me say that even in the select committee report, if an officer is raided or caught red-handed, there is no provision for requirement of any sanction for prosecution or investigation, etc. Only in cases where there is no such raid or search or seizure happening, not that authority, but a competent authority, a separate authority, would take a view with respect to the sanction, and that too has to be time bound, and thereafter the trial also has to be time bound. So therefore, if everything is expedited, both the sanction and the trial itself, everybody under the statute is duty bound to conclude all proceedings within a short span of time. I think it leads to benefit of the entire system.
Aman.
And that is what Mr. Jaitley was suggesting, that it's
Aman, the point that you're making is, no, I understand. I think the point that you're making is something that we will cover in greater detail about why this prior sanction is required. Just hold your thoughts there, because I want to go across to Sadanand on another very important part of this discussion. And Sadanand, what about the compelling argument that this inhibits fearless decision making and may penalize bona fide errors? I mean, the section that we're talking about, I make a decision, it's got to benefit someone somewhere, and then I have to justify that this was in public interest. Who defines public interest, and B, errors. I'm just trying to get both sides of the debate going. Sadanand?
I agree with you, and I think some of these amendments are absolutely commonsensical. For example, extending the idea of prior sanction to retired officials. You have a situation right now where someone may have retired from service 10 years ago, or 15 years ago, or 20 years ago, and then suddenly somebody else decides to rake up some case. It really does. If you put yourself in the shoes of the decision maker, this is like some kind of permanent sword hanging over people. And the actual practical effect of this is to make people who are honest think twice before making a decision that is rational and helps the people of India. It does not affect the dishonest people, because the person who is out there to sort of make money or take a bribe is going to find a way to do that anyway. It's the people who are concerned about their reputation, who are honest, who find their hands tied. That's the first point. The second thing, there are other sort of sensible potential amendments, such as putting some kind of time limit. I believe it's a 4-year time limit on these cases. Again, the problem with the current system is that something can go on and on and on for 5 years, 10 years, 15 years, 20 years, absolutely destroy someone's reputation in the process. And in the end, the person may end up being completely innocent. So you have to understand that what has happened over the years in India is that some of the anti-corruption fighters, who I respect tremendously and I think of as well-meaning people, have in their zeal ended up creating a system that does not punish the corrupt, but in fact paralyzes the honest.
Okay, respond to that, Mohammed Khan, since you are tonight defending the fact that these amendments should not happen. Respond to the point made there by Sadanand Dume that these amendments will actually paralyze the system and are not going to in any way affect the corrupt.
Right. Sandeep, my answer is the following. I remember reading once upon a time, and I think it is an apt saying in this situation, the law is written in black and white, but it is implemented by human beings who come in shades of grey. That is the problem here with the CBI or any other investigating agency. They apply a standard of zeal and enthusiasm to political victims or people who are the subject matter of political vendetta that you do not see, that zeal and enthusiasm you do not see in other cases, right? There is nothing fundamentally wrong with the law. Strengthening laws is, of course, what a government is elected to do, not dilute them. So when the agencies act in a manner which is prejudicial, where they act to intimidate, where they act to arrest without reason, where they act in such a manner that it goes against the interests of the person being investigated. That is why we have due process. You strengthen the process of law to ensure that a person gets a fair trial, that a person gets to give their position before the relevant authorities. Don't hound them, don't victimize them, don't go after them in such a fashion that their careers are ruined. These are truisms, and that is what the government should focus on strengthening. Take actions against errant officials. Say, for example, a person is ultimately acquitted and there was a corrupt official who went after him on the basis of a political vendetta. What remedy do I have against that official? Do you know, and I've said this before on your channel, income tax officials are empowered to conduct raids on your premises with impunity, because 2 years ago in the Finance Act, this government said that their actions are beyond judicial review, beyond the scope of scrutiny. So any individual can raid your house, whether to inconvenience you or on genuine charges, and his actions cannot be questioned in a court of law. So come on the one hand you're talking about, oh my God, we need to protect our officials. On the other hand, you use the CBI and the ED and the income tax authorities like your personal watchdogs. So please, this is hypocritical on your part to have this debate and not all sanctimonious.
Mohammed, yes. Absolutely, absolutely. Mohammed, I'll just come to you in a bit. We'll request you to switch off I think the audio in your television set. It's kind of interfering with ours on air. But Mr. Venkatchalam, I'll come back to you and we'll respond. And I want you to respond to a point that Sandeep asked and Mohammed Khan responded to. At the end of the day, there is a cost of this paralysis. The banking system has choked because PSU bankers are too scared to take credit decisions. The whole idea of an IBC was because bankers were not taking decisions. They knew they will take a discretionary decision on a haircut here and they could be hauled up in a court of law 10 years after they've retired. Some people could not even work and had to come to court, in cases like these. All I'm asking is that how does one restore confidence? And the question I think we tonight need to also raise is, do the existing laws offer adequate protection to the honest officers? Mr. Venkatchalam.
Yeah. That's very important. That's a more question that we have to address today. Of late, we are finding that in the banking industry, this interference is happening now and then. And so naturally it's a question where the honest officials feel that it is very difficult to take decisions, give loan. But it cannot be disputed that there are some black ships in the banking industry also. There is a nexus, a political nexus, a bureaucratic nexus, and the corporate big business, and including some black ships in the banking industry also. It cannot be disputed. But the point is that innocent people, innocent officials, innocent top officials of the bank should not be unnecessarily harassed. For example, that's what I believe has happened in the Bank of Maharashtra case, that the case of D.S. Kulkarni is entirely different, where the bank is not involved, the bank managing director is not involved, the ED is not involved, even then the state police has involved them and have been put into detention, and now the reputation has come. And now this is the irony that finance minister says that this is wrong, how it can happen, but under him the same government director and the other people in the board have taken a decision to divest the managing director of all the powers. So it doesn't tally. What they talk is something, what they do is something. So that's why I said they have an agenda, but definitely we believe that honest people should not be harassed, and they must be taken care so that they are encouraged to take bona fide decisions.
That's the crux. That's the crux of the debate, isn't it, Mr. Venkatachalam?
That we are finding that
sure.
the bad loans.
Allow me to interrupt you there, sir. That's the crux of the debate, that you don't want honest people to be harassed, and yet you want the guilty to be punished, and that's why we're having this debate. But Prashant Bhushan, let's get down to another specific clause of the amendment, and I want to hear your opinion and your objection to it so that we can debate that. The bill also raises the threshold of proof to prove someone guilty of having disproportionate assets. As now, it's not enough to just prove that a public servant has assets disproportionate to his means of income, but the prosecutor will now need to prove that these assets were acquired with the intention of the public servant to enrich himself illicitly. So, in some sense, they've also diluted a critical clause, or they're seeking to dilute rather a critical clause when it comes to disproportionate assets. Do you believe this is another significant dilution, and why are you against this?
Yes, this is clearly a significant dilution, because how will you, it will be just as sometimes it is not possible to prove that the person has taken illegal gratification for a corrupt decision which is without any rationale. For example, in 2G, the decision that it will be first come first served on the basis of who reaches the window first, and there are fisticuffs there, and the differences are 30 seconds, 20 seconds, etc. as the time at which people deposit their applications. Now that was clearly a corrupt decision. There is no doubt. There is no rational basis for such a decision. So therefore, if in that you have to prove that illegal gratification has also been taken, it will be impossible to catch the corrupt in this country. That is why 13(1)(d) was introduced in the Prevention of Corruption Act, that where you have a manifestly corrupt decision or a fraudulent decision, where it can't be justified on any touchstone of public interest, where clearly authority has been abused to take that decision which has been made to benefit somebody financially or give any undue benefit, then that has to be prosecutable. If you say that no, you have to prove that illegal gratification was acquired, then it will be impossible to prosecute. Same thing about disproportionate assets. If a person has disproportionate assets, he has to prove that he has acquired them on the basis of legitimate sources of income. If he can't prove that, why should the prosecuting agency have to prove that he has acquired it by corrupt means, etc.? It should be assumed that he has acquired it by corrupt means if he can't prove that he has acquired them from any legitimate sources.
No, that's a valid point indeed. And Aman Sinha, I have two questions, and I'm going to take a cue from what Mr. Prashant Bhushan said. Do the proposed amendments, and seemingly they do increase the burden of proof necessary for punishing the corrupt, and in that sense, it is against what the government has been saying so far. And what about political sanction for prosecution? By expanding the scope of the same, are we strengthening the Babu Neta nexus? Why should the government that is perhaps going to be, where allegations are being risen, and I'm not talking about your government, I'm talking about any elected government in general, be the one giving a sanction?
Supriya, first of all, we must all acknowledge that this is a report of the Select Committee. It has members cutting across all parties, including the Congress Party. And I do not know which is the correct version of the Congress Party, the stand which they took in Select Committee or what is being stated here. But obviously, it's self-contradictory. The fact of the matter is that these are all proposed amendments. They will be debated in Parliament, and to my sense, these amendments are going to lead to strengthening of the Prevention of Corruption Act and make it more pragmatic, realistic, so that the goals and objectives of the Prevention of Corruption Act could be fully achieved. Now, I do not wish to comment much on what my friend from the Congress was saying, but those days of Congress Bureau of Investigation and caged parrot, CBI being a caged parrot, that everybody knows. And the Congress Party should be clear whether they are supporting this or they are opposing this, because they seem to be taking contradictory stands on each and every issue. Now, as far as your questions with respect to investigation is concerned, clearly there will be no investigation, sanction for any investigation or sanction for prosecution in cases where any official is caught red-handed or anything any serious offence is committed and they are caught red-handed. Obviously, there is not going to be any sanction for investigation or prosecution. However, in several cases, that there are several occasions where people are targeted also. In those cases, what is the difficulty if within a time-bound period, a very short period, perhaps of 3 months, if I recollect correctly, sanction has to come either way, and it can be open to judicial scrutiny subsequently. So it is for better of everybody, and the systems they become more efficient and they become more transparent. I do not know why anybody should be having any problems with that. And let me also assure you that 13(1)(d) is not going to be diluted. In fact, it is going to be strengthened.
Okay, fair point, and we have to wait for the fine print of the Select Committee. I take that point on board, Aman Sinha. Right now, we're all speculating. I can see Prashant Bhushan nodding. I'll come to you, sir, and Sadanand as well. But only fair that I get Mohammad Khan to react to what you said. Mohammad Khan, it's only fair that you clear what is the position of the Congress Party? Because honestly, we were under the impression that on one matter there is consensus between BJP and Congress, and that is on diluting the provisions of the anti-corruption law. But because even the Select Committee, there seems to be some sort of consensus. But you're taking a different position. What is the position of the Congress Party?
Absolutely. I'll explain why. Number one, when they first proposed this amendment, we opposed it on the floor of Parliament. In fact, that is why they had to send it to the Standing Committee and the Select Committee. It was on our insistence. Number two, we held repeated press conferences highlighting the fact that this dilution would not stand. Number three, we linked it at the time, and I know it might not be germane to the instant point, but it is important to say, we linked it to the lack of political will here and the absence of a Lokpal. We have raised this issue multiple times. Aman Sinha ji speaks about the Select Committee report. There are several Select Committee reports where certain members' opinions have not been taken on board. The Select Committee's report is often the product of consensus of the majority, not necessarily of the minority. I would wait for the report to read it, sir. I wouldn't rush to judgment. I am certain that having taken the position on the floor of Parliament against it and in the public domain, we wouldn't be taking the sort of unanimous position that you seem to be suggest we are.
Yes, yet to be tabled. How can you take a position on floor of the House? Obviously, the positions have been taken in the Select Committee,
exactly.
and the positions which have been taken are in contradiction to what is being stated here. And in any case, Supriya, all these banking scandals, they are common.
I was referring to the position we took on the floor of Parliament when it was first tabled.
Structure that Congress Party put up.
1 second.
We are trying to strengthen and empower our institutions in fight against corruption. If Congress Party is feeling jittery about it,
there are the two political spectrums will look at this entire thing very differently. I think
so set up the Lokpal if you have the political will.
Where you stand on issues is exactly where you sit, and I think that is where I'm going to come to the Lokpal later. But I'll go across to Sadanand. And Sadanand, the new bill also proposes doing away with exemption granted to bribe givers. So now they will be treated at par with bribe takers. I'm just curious to understand who on earth is now going to report the fact that they had to grease palms. Will this deter bribe givers from appearing as witnesses because they are going to be treated at par for a criminal offense just as much as the bribe receiver?
I mean, let me get to that, Supriya. But before we sort of, we've been kind of this whole discussion. We've been diving into the weeds on all kinds of things, right? Section 13 and 1D and so on. What I find frustrating about the broader debate that we're having over here and the broader discussion about corruption in India is that we pay way too much attention to finding ways to go after crooks. We pay too little attention to minimizing the number of crooks that you create in the first place. If we had a more rational discussion about corruption in India, what we would be looking for is ways to simplify laws, simplify regulation, and make it extremely easy, raise salaries dramatically for people who are now in charge of a $10 trillion economy, both in the political class and among the bureaucracy, and create circumstances where only a few people are tempted by corruption, and then you go after them. But we're not willing to have this discussion. Instead, we have the same old discussion over and over. Let's strengthen the CBI. Let's get the Lokpal. But the fact is that these institutions are going to be manned by the same people, and we have absolutely no reason to believe that suddenly, miraculously, someone by going and working for the CBI becomes an incredibly honest, upright person. So I just want to sort of flag the fact that the debate itself, I think, gets the wrong end of the stick. Now, secondly, your point about bribe givers and bribe takers, I think, is well taken. If I'm not mistaken, it was Kaushik Basu who had suggested that one way to change the incentive structure would be to say that bribe givers would not be prosecuted as long as they were able to sort of speak out against bribe takers, and that would really put the onus on the official who is asking for the bribe. But in the end, these are kind of tweaks. These are minutiae. We can sort of debate this clause and that clause. The larger question is, how do we look at this problem of corruption? How do we look at it the way countries that have successfully solved it, like Singapore, in a practical, hard-headed way, or do we look at it in this way that is overwrought with emotion? And I'm afraid that we're in the latter category.
Prashant Bhushan to respond. That's a spirited point made there by Sadanand Dume. Mr. Bhushan, I'd like you to respond to his argument there, and I'm adding a question. I want to hear your view as well on this clause that sort of equates the bribe giver and bribe taker. Do you think this could deter bribe givers from appearing as witnesses?
Well, there is already a provision in the law which makes abetment a crime. So a bribe giver is certainly abetting a bribe taker. So even today, under the existing law, bribe giver is liable to be prosecuted. But I agree 50% with Kaushik Basu's point that the bribe giver should not be prosecuted if he has had to give a bribe to get his legal entitlement. A large number of people in this country are having to pay bribes even to get their legal entitlements. So such bribe givers should not be prosecuted. But if a person is giving a bribe to get more than his legal entitlement, to get something undue, then certainly he also needs to be prosecuted along with the bribe taker. But having said that, I agree with Sadanand Dhume that there are other systems which need to be strengthened to prevent this whole atmosphere of corruption in the country. One of them was transparency. Now, I'll give you an example. The Supreme Court about 2-3 years ago had given a judgment saying that the Reserve Bank is obliged to provide information about willful defaulters, about other defaulters, about various other financial frauds, etc., under the Right to Information Act. But despite that judgment of the Supreme Court, for the last 3 years, the Reserve Bank as well as the government has been studiously and very, very strongly opposing the release of this information. So, unless you have transparency about various decision making, even about lending by banks, you see, you make it transparent, that will reduce corruption in the business of bank lending to a substantial extent. There is no doubt that there is substantial corruption in the business of lending by banks. Same thing about the whistleblower law. There is a whistleblower law. Unfortunately, for the last more than 4.5 years, it has not been operationalized. That law came more than 4.5 years ago. It has not been notified for no good reason at all, thereby preventing whistleblowers from coming out and disclosing all these crimes of corruption that are going on. So, therefore, all these things need to be done, and we need to bring in place the Lokpal as well as strengthen and professionalize the CBI and stop the politicization of the CBI, appoint the Lokpal, place the CBI under the control of the Lokpal, then these laws will be properly implemented.
Okay.
But Aman
All
Sinha,
right,
you want to respond to Aman
Aman?
Sinha, you want to respond to that very quickly? The point made there by Prashant Bhushan.
Yes. Yes.
Okay, I think we've lost the link there with Aman Sinha. We'll try and reconnect with him. But I'm glad we're taking it beyond this sort of narrow debate on the amendment to the Prevention of Corruption Act and looking at the bigger picture. Mr. Venkatachalam, let's look at the sort of bigger picture. Can you, as we wait to re-establish that link with Aman Sinha, if he's back, I'd like to go back to him. But Mr. Venkatachalam, sort of as we pause and look at the bigger picture, can you deny the fact that, as Union Minister Jaitley says, and I'm quoting him here, there is an immediate need for us to put this entire relationship between investigation, who to investigate, when to investigate, what constitutes a crime, this really needs to be put in its place if we want effective decision making and economic decision process not to be delayed?
You see, I didn't get your question fully. But the point is that it's not only today that banks are giving loans. Banks have been there at least for the last 100 years. Banks have been giving loan. Money has been coming back. But today we find that a new problem is coming only because there is a willful default, and naturally there is a scope to suspect some corrupt activity. And that's why all these issues are coming. So definitely there is need to be transparent. The bank lending has to become more transparent, more accountable. It is not that only some individuals are taking, there is a due process of sanctioning loans, etc. And if there is some element to doubt some corrupt activity, that can be investigated. But the point here is the bulging bad loans. Because a loan becomes bad after some time, it does not necessarily mean that there was corruption. It's quite possible that today I give a loan on a bona fide ground, and maybe after a year or 2 or 3 or 4, 5 years, the loan becomes bad for many other reasons. So it is wrong to link up the loan becoming bad subsequently and the decision taken at a particular time when the loan was given. But this is getting confused today, that as though people feel that any bad loan, it means that bank officials are corrupt, bank people are taking money and then they are sanctioning loan. That is something which is hurting the people. Majority of them are honest people. Majority are compelled to do banking business. Banking, lending is very important, and we have to lend only. Right from managers, it is not only managing director. At the branch, there are 85,000 bank branches. In every branch, the manager has to sanction loan. So it may not be the corporate loans, but he is giving so many loans. So it is wrong to suspect that every loan there is an involvement.
I think you're kind of changing your position now, because you said
this,
yes, Mr. Venkat, absolutely. But that's exactly the point. We began this show with Mr. Venkatachalam, that not everything is malified. Things could be a bona fide decision. They could have gone wrong in hindsight. That's the position we took to begin with, but I think you're a contrasting position. But then I'll go across to Sadanand Dume. And Sadanand, there is also this dilemma, and I'm going to put it out in public even at the cost of being a little unpopular here. Tough anti-corruption law, which is what India needs, is in some sense direct contrast and conflict with economic prosperity, economic growth, because it impedes agile decision making. How does a nation strike a balance between these two? Is this an easy trade-off?
No, it's obviously not. I don't think it should be viewed as a trade-off, right? I mean, I think every society has to deal with corruption. You can't simply say that I don't care about corruption and hey, I'll start caring about corruption when my per capita income hits $10,000. No country has that luxury, and no public will tolerate that. So, on the one hand, you have to understand that people are concerned about corruption. Those concerns are genuine, and any elected government has to do something about it. On the other hand, you don't want to approach it in this way that ends up hobbling your capacity to move on. Now, if you look at the historical experience, most countries have, in fact, tackled corruption as they've grown richer, right? I mean, if you look back in, I'm in the United States. If you look back to the United States about 100 years ago, you had Tammany Hall and you had the most awful corruption, and it was sort of fixed over time. That has also been the experience of most European countries. So you continue to fight it, but you don't fight it in a way that is counterproductive. And my criticism of this government, as you know, that I've made repeatedly on your program, is that they have gone after it in a way that has ended up hurting economic growth, and ironically, in the long term, may in fact end up slowing the fight against corruption, right? So this obsession with black money, for instance, giving income tax officials draconian powers, for instance, that Mohammed Khan spoke about, all of these things are on the other end of the spectrum. I happen to think in terms of amending this law, that they are doing something that is a little bit sensible and that allows decision making to happen quickly. And so it's a pleasant surprise to see them doing some things on the right end of the spectrum when they have done many other things on the wrong side.
Aman Sinha, I'll come to you exactly on that point. While many people believe that this is perhaps the right thing you're doing as far as the economy and economic growth is concerned, your government has now been in office for 4 years and 2 months. Why have you delayed this for so long? And who is going to be blamed for this particular amendment not going through? 2 bills have been tabled in the last 3 years. One by UPA in 2013, then by yours in 2014, and then it went to the select committee. Everything has been ready. Why the delay? And will you concede that the lack of this amendment to the Prevention of Corruption Act actually fueled a policy paralysis in UPA? It suited you, and so you opposed it then. You want to go all guns blazing now.
No, Supriya, our stand has been very clear and consistent from day one, and the amendments which have been proposed, our party has taken a clear categorical line on that. The difficulty arose because of lack of political consensus by other political parties and our adversaries in Parliament. I do not wish to dwell into details, but the fact of the matter is that today these amendments are proposed by a select committee after going through the entire Parliament has its own procedure and processes, so that every law is balanced, all perspectives are factored in, and therefore it might take a little time, on a few occasions. But I do believe that whenever this bill is tabled, maybe in the coming session itself, the Congress party and other political parties, they will support all these very pragmatic, realistic measures which have been proposed to strengthen the Prevention of Corruption Act. Now, about the point that Mr. Dhume was making, let me say that our country has been growing at a very rapid pace. For past 4 years, we have been the fastest growing economy in the world, and I can assure to you that for next 8-10 years, as long as our government is there and Narendra Modi ji is Prime Minister of this country, we are going to be the fastest growing economy in the world. And that apart, we have not deterred in taking several transformational measures, several strong decisions, because they were in the best interest of the country, whether it was demonetization, GST, or several other legislative initiatives which have been taken. And therefore, I feel that this is an initiative to strengthen the Prevention of Corruption Act. It will make our systems more transparent and efficient, and it will somehow lessen or diminish the red tape which exists, and it will finally help us in our economic growth as well as in our fight against corruption.
Khan, I'll come to you. Right, Mohammed Khan, I'll come to you. This bill was originally introduced in 2013 by the UPA. So why are you now opposing it? I mean, I'm just talking from the moral compass point of view. Why are you opposing a bill that in any case should have come in? You've paid a price for policy paralysis. You still want to oppose it?
Right. Well, the bill, as Mr. Prashant Bhushan pointed out at the very outset, the bill introduced by us in 2013 and the subsequent amendments made to it by the NDA government when they came to power are slightly distinct creatures. You will notice that I focused my criticism, my party's criticism largely on the sections with regard to prior sanction and those with regard to whistleblowers. Those are sections that have been modified under the BJP. That is why we stand in opposition to them. But I want to say on a lighter note, I think Mr. Bhushan has left, but on a lighter note, I wanted to tell him that it is very heartening to hear him endorse Congress laws such as the Whistleblower Act and the Lokpal, which he was staunchly opposed to 4 years ago. So, you know, time makes for strange things, I guess. I want to say also to Mr. Aman Sinha, Mr. Aman Sinha, we are not obstructive. We don't stand in the way of progress. You have to provide us with a reasonable differential as to why you want to bring this law. That is the job of the opposition. We must be vigilant when you, in our opinion, seek to try and dilute laws. You will forgive me. I question your intentions. I question your government's intentions because you've had 4 years. At every opportunity you've had to make our system more transparent or strengthen existing mechanisms to fight corruption, you have failed. The Lokpal example is the best because it's most recent. The Supreme Court wrapped you twice in the span of 3 months, the most recent being a few days ago, where they said you are adopting evasive and delaying tactics for the appointment of a Lokpal.
There was a scathing
by
indictment
Number
of
two,
the
you
UPA
remember 4 years ago when
government by
the Supreme Court said,
with respect to several measures.
You remember 4 years ago?
With
Sir,
respect
UP
to
has nothing to
omission
do
of
with this,
several
Aman sir.
measures
Aman sir, I didn't interrupt you while you were
fight
talking.
against
Come on,
black
Aman sir,
money.
we can't debate like this.
Whether it
Aman
is
sir, come on, I didn't
on-
interrupt you.
No, may I
Aman
just
sir, I didn't
respond
interrupt
now?
you. Now,
Mr.
I
Khan,
want to
please
tell you
allow
one
me
thing.
to respond.
Aman Khan, Aman
4 years
Sinha,
ago,
I
you
don't want,
remember
I
you
don't
stood
want
in the
this,
Supreme
I
Court
don't want
and
us
you
to
said-
end this debate on a political
said-
slugfest. Let me interrupt you both and take one simple question. You made your point, Mohammad Khan. Let's not end on a political note, and I'm going to let Sadanand have the last word. Sadanand, this environment of rampant mistrust as is visible. Do you believe these changes realistically can be made? Do you believe that this government will stake it's all right for Arun Jaitley to say this in an address to bankers at an SBI conclave, but will the government stake its political capital on this? Will there be political consensus? Do you think all parties will support such a move? Is it, or the negative optics of it, do you think that could come in the way of any move to reform the anti-corruption law, if we may call the word, because dilute is not going to be a pleasant word to use?
Yeah, I don't think dilute is a fair word to use. You can use, it's a loaded word. You can use the word rationalize, which would be a positive word. I don't know how this is going to play out, honestly. I do think that this is brave of the government to raise this because, the way these debates are structured, anything that you do that sort of rationalizes things and that moves towards the practical end of the spectrum, that moves towards speedier decision making, that moves away from this kind of mob-like mentality where everybody else is a crook, it always has political costs. Both parties exploit it. Congress will exploit it when it's in the opposition. The BJP exploited it when it was in the opposition. I think it's brave of the government to try and do the right thing under these circumstances, and I wish them luck. I'm not sure whether they'll be successful or not.
All right, on that note, thanks very much each one of you for joining us on this edition of the India Development Debate as we put the spotlight on the massive amendment that the Prevention of Corruption Act deserves to see, and if there can be a political consensus on that. Thank you very much indeed, each one of you. Corruption clearly is a cancer that is deeply entrenched in our society. But from the lowest clerk in the ladder to the highest offices, it is a matter of shame where we as a country, as a nation, fare in report after report on graft and on corruption. Public officials need to be empowered for taking bold decisions without fear of harassment, but the onus to make fair decisions that benefit the last man standing also rests on them.
That's right. Economic prosperity and clean governance are not mutually exclusive. They are and must be made to coexist. Graft can never be the price India must pay for high growth because corruption corrodes the very foundation of what our economy must be built on. Thanks for watching this special edition of India Development Debate. Up next is Top 10 at 10.